Will you be deported if you overstayed your visa and then apply for the marriage green card? With the new USCIS policy changes, this is one of the most common questions I've been getting, and the answer might surprise you. In this video, I'll break down in simple terms so you know your risks before you apply. I'm U.S. immigration attorney Sharifa Tharpe. I help immigrants to stay here and apply for the work permit and the green card. Now, I want to explain how the new USCIS policy manual changes affect people who overstayed their visa and want to apply for a marriage green card. Marriage to a U.S. citizen or a green card holder can open the door to legal status, but not every case is the same. And if you apply when you don't qualify or you don't apply for adjustment of status application at the same time as a petition, you could end up in removal proceedings. That's why understanding these new rules is crucial. Let's start with the best case scenario. If you're married to a U.S. citizen and you overstayed your visa, you generally have the right to apply for your green card without leaving the country. The adjustment of status application is what gives you that temporary protection while you wait. Now, the USCIS typically allows spouses of U.S. citizens to adjust status here in the United States because it is the law, even if they overstayed. That means you're less likely to be deported just for filing unless something is wrong with your application. Like, for example, you miss crucial documents like the adjustment of status application or any waivers that address admissibility issues. Now, here's the key. If your paperwork has mistakes in there, if your forms are incomplete, if there are documents that are missing, if there's evidence that's missing, or if you submit inconsistent information, USCIS can deny your application. And now under the new policy manual changes, when a case is denied, USCIS can issue a notice to appear. That's a document that starts deportation proceedings. Now we're seeing notices to appear being sent on auto upon denial or rejection. So it's no joke. So while being married to a U.S. citizen gives you strong protection under the law, errors in your application could expose you to serious risk. Now, here's the other side of this. Applying as the spouse of a green card holder if you've overstayed. If you overstayed your visa and you're married to a green card holder, the rules are very different. In most cases, you cannot apply for a green card inside the U.S. after an overstay. Instead, you need to leave the country and apply through consular processing. But here's the risk. When you leave after overstaying, you could trigger a 3 or a 10-year bar from re-entering the U.S., depending on how long you overstayed while you were in the U.S. Now, applying for a special type of waiver may help with this, or your spouse has to become a U.S. citizen for you to stay here and apply for adjustment of status. Now, this means that your overstaying makes your case more complicated, and if you apply for a petition alone without an adjustment of status application, then it puts you at risk to get a notice to appear for deportation. That's why it's important to understand when to apply as a spouse of a green card holder, and also to understand how these new changes could affect you. Now, if you apply for something you don't qualify for, like the adjustment of status application, that's going to increase your risk here of deportation. That's why it's crucial to confirm you're eligible before filing. So for U.S. citizen spouses, you have more protection, but you still need to avoid mistakes. For green card holder spouses who've overstayed, you need to look at waivers or your spouse becoming a U.S. citizen. Applying with just a petition alone or applying for adjustment of status when you don't qualify for it is going to be harmful to you and put you at risk. So, will you be deported if you overstayed and apply for the marriage-based green card? If you're married to a U.S. citizen, you can apply inside the U.S. and you're less likely to be deported under the law unless there are serious mistakes in your application that lead to a rejection or a denial. Now, if you're married to a green card holder and you overstayed, your case is much riskier because you may not qualify to adjust inside the US, and leaving to apply abroad can trigger long bars that prevent you from returning. Those bars, as I said before, could be 3 to 10 years. That's why you need to know for sure how you're going to approach this and whether you do in fact qualify to apply before you file for this, because having that on record means you could get a notice to appear. Now, if you're in this situation, don't guess. Talk to an experienced immigration attorney like us here at ST Law Office. Now, the difference between qualifying and not qualifying could decide whether you get the green card or end up in deportation court. Go ahead and click on the link in the description of this video to get in touch with us and get scheduled so we can talk to you about your options forward. And even if this can't work, there may be other options we can explore. Now, if this video was helpful, like, subscribe, and hit the notification bell so others can see this information that can empower them through their immigration journey. And so you can keep getting good updates like this. Remember, you don't have to face this alone. That's why we're here to help. I'll see you in the next video. Until next time, take care.